Acting Public Protector Kholeka Gcaleka has given an update on some of the investigations done by the Office of the Public Protector. Some of the most prominent investigations include those of President Cyril Ramaphosa, who was cleared of violating the Executive Ethics Code after a complaint was laid by the Democratic Alliance following a leaked recording of Ramaphosa speaking on ANC campaign funds. In another update, Minister of Public Enterprise Pravin Gordhan was cleared of any wrongdoing in the appointment of his Chief of Staff, Nthabiseng Borotho, following a complaint by the EFF. However, Gcaleka ruled against National Assembly Speaker Nosiviwe Mapisa-Nqakula unlawfully and improperly chartering a flight to Zimbabwe with ANC delegates. For more on this, we speak to legal analyst Mpumelelo Zikalala. Thank you very much for availing yourself this morning. Perhaps let's start with the relationship between the Office of the Public Protector and the state. How should we understand it?
It should be that of an oversight role, the one of saying you have a set of rules in which you are supposed to stick to as the state. There are certain things and compliances that you have to do. And my role as a public protector will be to check, have you been able to do those particular things? Is it done according to the law and the prescribed legal prescripts? If the answer is yes, then you've done good. However, if the answer is no, I then recommend remedial actions, which are actions in which are supposed to make sure that you place the person who is aggrieved in the same position they would have been had it been that the injustice didn't occur. But what you've been seeing lately, especially with these two reports, is the identification of certain gaps in those legal prescriptions which are supposed to apply or ought to be applied by the public protector. However, the public protector is silent on those. I do understand it, though, that she can't really pronounce on those loopholes in the legal prescriptions in these particular reports, but we do hope that at a later stage, those particular loopholes are going to be highlighted and will be made aware, or the legislature will be sort of guided to say, please can you beef up the ethics code in this particular manner? Can you please beef up the Public Protector's Act in this particular manner? And also to support that would be the recent judgment which was taken by the Constitutional Court in terms of the accountability of the political bearers or the politicians when it comes to their campaign funds. So it is clear that yes, the Public Protector is playing within the four boundaries of the legal frameworks that are there, but there are clearly loopholes that are there that are sort of misguided as to what the intention of this particular ethics code legislation that is there meant to promote accountability. In certain instances, they are not doing exactly that.
With those loopholes in mind, how effective then has this office been in playing this oversight role?
The office will be effective in the identification of these loopholes. Now, what they are simply doing is saying, these are the legal prescriptions that have been given. These are the facts that have been given. I'm going to rule in this particular manner. And it simply ends there. What ought to happen is that it should be a stage further in terms of saying, this is what I recommend the Ethics Committee or Parliament or the legislature should do to make sure that they're able to cover these loopholes. The suspended public protector tried to do that, but in doing that, you should embed those particular recommendations into the reports, and that is part of why those reports were then ruled as being unlawful or should be struck off. So there's another important point in which I think Parliament, when it comes to the level of accountability, they should then come back and say, how do we make sure that we're able to listen to our public protector and take our recommendations seriously, so that at the end of the day, the aims and objectives of why these instruments are there are not some things which are simply a compliance basis and it ends there. Let me make another example. Let's take the case of Minister Pravin Gordhan. We have someone who's employed in his office who does not have the relevant qualifications, and the only thing in which the minister is relying on is the level of experience. Now, the question would be, is it fair for someone who's sitting at home with the qualification, relevant experience, not to be given an opportunity to apply for that particular job just because there's a certain provision which allows for those particular concessions to be made? Secondly, there's no investigation as to whether is there even rationality in allowing a particular individual to occupy that particular office. However, just because the Public Services Act allows it for ministers to make a discretion, just because the Public Services Act allows the Public Services Minister to make certain concessions when applied, it then suffices the compliance check. So it's simply just a tick-box exercise, but the intention and the rationality behind why those particular legislation which is passed is not really investigated. And part of it is for the Public Protector to then say, can you please look at these particular loopholes when you are developing the law at a later stage? Don't wait up until the Constitutional Court is going to tell you so, because there's litigation that has taken place. Be proactive and make sure that if you are really serious about accountability, close this loophole so that when a person who is in public office takes a decision, it is really a decision which is in the best interest of the members of South Africans at large.
It is also not unusual for persons of interest, when they find that perhaps some of these loopholes were not closed or investigations have been compromised, they then take a matter forward. In this instance, the acting public protector clearing the president with relation to the allegations that were made by the suspended ANC MP Mervyn Dirks. What to read into this situation, if anything at all, right? So the case is closed, according to the acting public protector. What options are then available to those who had laid the complaint in the first place?
You can go to court and simply say to the court, we simply believe that the formalities or the procedure used by the public protector is an incorrect one. The manner in which she has done this particular investigation has caused her to arrive at the incorrect decision, which is at the end of the day saying that the president must be exonerated or there's nothing wrong that the president has done. I'll come back to this point of saying on the technical basis, yes, the president may be correct, but on the moral compass, on the compass of saying that you want to have a president who's accountable, how do you rationally bring together a president who's going to say in an internal ANC meeting, I know of individuals which are using public monies in an improper manner. However, I'm not going to say anything about them, and I'm simply going to let it be because it's something which is in the public discourse. There's nothing extra which is being stated by the president. Are you investigating these individuals? Are you condemning this type of behavior? Are you taking any action against those individuals? Are you doing anything to curb those things at the end of the day in which public funds are going to be used to fund internal party processes? You ought to act as a president who then says, I'm the number one citizen of this country. I want to make sure that I'm able to protect your funds as much as I can. Let's remember, government does not have funds. It is broken. The only people who help to fund government at the end of the day is us as taxpayers. So their own obligation of saying that because we give our hard-earned money to pay tax, you are going to make sure that you handle it in the most careful manner and make sure that it is there to benefit us as members of the public and not anyone else. Now, if you're going to find instances where there are instances of abuse, where those funds are not being used in a proper manner, as the president, you ought to act. You may not have a legal prescript right now, which then allows the public protector to say that you've done something wrong. However, it falls upon you and the legislature to then say, how do you put in processes in which you're going to force the president to come and disclose this information whenever it is found to be there, for the president to follow up this information so that we curb this thing from ever happening again. With the current reports that we have now from the public protector, there's nothing preventing the same situation from happening in 2024, and nothing can be done about it because the legal instruments that we have are not adequate enough to make sure that there are certain repercussions or consequences which are going to follow on those that have done wrong.
Let's continue with that theme because there's more. The acting public protector also found that the Speaker of the National Assembly, Mapisa-Nqakula, breached the Constitution by taking a delegation of ANC members and chartering them on a plane to Zimbabwe. Again, then what?
You see, there's a clear example, a prime example of a legislative framework which works and that can be able to produce results. Now, what would follow from that is to say, Speaker, you've done something which is wrong. It's not supposed to be there at all. If in another planet or in another country, you would have resigned by now due to being contravention of the ethics code. But most importantly, let's be able to recover the funds in which you were engaged in. At the end of the day, the funds that were used to charter ANC members to Zimbabwe were not funds which were meant to be used by the ANC exclusively. So those funds must be paid back, and the coffers of the public coffers must then be replenished so that we're able to use those funds in an appropriate manner. That's a prime example of how the work of the public protector should be and how things ought to be done so that at the end of the day you're able to produce results. This whole process of the public protector engaging in these particular investigations and coming up with recommendations should be able to yield positive results which are tangible, and they're only there to ensure one thing. Make sure that the public purse is protected at all times. In instances where the public purse has been compromised, bring it back to the manner or into the level that it ought to have been. So pay back the money, but most importantly, put in ways and processes and stops and balances which are going to prevent this type of transgressions from ever happening again. But
South Africa is not the only country with a public Protector, if we take a look or measure ourselves against what other nations are doing, how would you say we're faring?
I would say on the part that we do have an Office of the Public Protector which is able to investigate this type of matters, I would say we're doing okay. In the office in which is supposed to take a developmental approach in the manner in which it's supposed to do its work, that's where I would say we're a bit of lacking in a lack of a better word. In terms of saying we must then find ways of saying how do we improve these processes, how then to improve the legal instruments that we have to do these investigations, so that at the end of the day we're able to extract the intention of why the Office of the Public Protector was actually put there. When it comes to interferences from other third parties, I would say when it comes to accountability, you have political parties having a say and be able to lodge complaints, those complaints being investigated. And in terms of those particular reports being sort of looked at again or being adjudicated by a separate body, in this case, which is judicial, I think again we're doing okay on that particular sense. So we are on the right path. Let's also remember that this is an office that has been there, I think, for plus minus 21 years, if I'm not mistaken, or even lesser. So there are things which would need to learn. There are going to be moving targets, especially when you are dealing with corruption and maladministration in certain instances in which people are not behaving in the manner in which they ought to behave. That's why legislation also keeps on amending on a regular basis to counter all those things. But I think for now, we have mastered the formalities of that particular office in terms of the complaints. Let's master the intention or the investigative part of that particular office, and also look at the intention of why those particular instances or laws were actually created. The objective being, we want to make sure that we get rid of corruption, make sure that ultimate accountability, and make sure that we're able to recover whatever that has been paid improperly. If you focus on those things, I think we'll be on the right trajectory.
Mpumelelo Zikalala is a legal analyst. Thank you plenty for your time this morning.